It's the Barely Legal Radio program. Joe Escalante here every Sunday. KEIB, AM 1150, The Patriot. And it's entertainment law, any business deals that happen in Hollywood, we try to stay up on them. Intellectual property, copyrights, trademarks, that kind of thing. And occasionally people call for actual legal advice. And we encourage you to do that whenever you want to. 877-520-1150, 877-520-1150. We're brought to you by LegalZoom. LegalZoom, where if you type in the referral code Vandals, the name of my formerly credible punk band, you're going to save some money. It's still a punk band. It's just after becoming a LegalZoom coupon, formerly credible punk band. Today's guest, we got a big one here. Super lawyer Evan Cohen is with us. Evan, thanks for coming in.
Great to be here.
Now, Evan is primarily a music attorney, right?
Yes.
And the name of your firm is, or your place where you're just a solo, right?
It's just me, Evan Cohen.
Good. I like it. And I've covered a lot of cases here on the Barely Legal Radio program, where cases I care about that involved complicated issues with musicians and record labels and copyrights. And Evan's name comes up quite a bit, and he's a fascinating representative for a lot of some of the coolest musicians around. And I've got him in here tonight to talk about getting out of your record deal. As a general concept, I get people calling me all the time, I got to get out of this record deal. And they might cite, they never paid me. And then when you get into it, it's like, well, they don't owe you any money, and really they just have to send you statements, and you've got to send them a letter, and you really can't get out of it. You can only sue for damages, and guess what? You have none. And so it's usually a loser. And then you almost get to the point where you just don't want to talk to these people anymore. But you have one that's a winner, because there is a way to get out of some record deals, just to terminate them. And they're usually in perpetuity, right?
That's correct. This is a law that's been on the books since 1976. This is part of the Copyright Act of 1976. This is Section 203. This is a very, very important law. This allows musicians, songwriters, anyone who has signed an agreement. It, of course, applies to other things like books and short stories and movies and things like that. But we're going to stick to music for now. It's all copyrights.
Is that like the Rear Window problem? Does that get into the movies one? Or is that totally different?
Well, the Rear Window case was based on a different copyright section, Section 304. All
right, I don't want to derail you. I don't want to derail you on that one.
But that was the same kind of termination issue. Okay. This is that was 20 years ago.
Okay.
This is a law that was enacted in 1976, but only took effect 35 years after 1978. So we didn't have this termination going into effect until 2013.
Did they know it was going to come into effect 35 years?
It was, but when I was a young lawyer and I joined the bar in 1985, 2013 seemed a long way away.
Right. Okay. So if someone signed a record deal in 1979 and it was in perpetuity, did the record label know that it really wasn't perpetuity? It was only a 35-year deal?
Well, yes, they did. Now, let me just back up a little bit, because I think it's important to distinguish. There's two kinds of deals that this law applies to basically in the music business. One are music publishing deals, and the other are record deals. Now, with regard to music publishing deals, you can use this law to terminate anything that you have signed, any kind of grant of rights, because this terminates the grant. This doesn't terminate the copyright. This doesn't affect the length of copyright. This terminates the grant of rights that you have given to a particular company.
For a composition. For songwriters.
For songwriters or compositions. Yeah. There's no question that this law is valid with regard to music publishing contracts. On the other hand, some record companies have taken the position that this law does not apply to record contracts because of several reasons. The main reason being that it is their position that when a recording artist records under a recording contract, it's a work for hire.
Right. For these particular recordings, and the guy can go and record more versions of it. So there's like more of a this is fair enough, because the artist can record another one and they can own that one.
That's correct. But
so why I paid all this money for this recording? Why are you taking it away from me?
Because that's what the law says. Now,
right.
I think the better view, I think the Copyright Office is taking this view, and most entertainment lawyers are taking this view, that sound recordings cannot be works for hire because they're not part of the...
I've heard that.
Yes.
They don't qualify as a work
right.
for hire like a movie does.
That's right. Because under the definitional statute, which is Section 101 of the Copyright Act, there's categories of things that can be works for hire, and sound recordings is not listed.
Okay, let me stop you right there, because I know that a lot of people driving around are going, what is a work for hire? I don't know what it is. My explanation is, if you want to still own the copyright of something and control it, like Walt Disney wants to control all these things in this and there's all these creative people working for Walt Disney, they hire them under a work for hire arrangement as an employee, so to speak, and then Walt Disney can own the copyright, and all those other people just get paid. They're hired to get paid, and then then Walt Disney runs around and exploits it forever. So, but that works great for movies, right?
In the movie business,
couldn't do it any other way.
Couldn't do it any other way. It's all work for hire. And with regard to Disney, I mean, they're very careful with their contracts, and also they actually do pay people to show up, sit at a desk, and write things.
Right. Yeah, they pay them insurance
and you want to
vacations.
Work here for 8 hours a day and write songs.
Yeah.
You can be a work for hire.
Yeah.
But the vast, vast, vast majority of creative efforts in the music business is nowhere near a work for hire. It's people writing songs on their own at home or whatever they do with the other members of the band or whatever. It has nothing to do with the company, and usually the songs are written before any deal is done.
Right, and then they might have been demoing and all that kind of stuff. So it was a bunch of guys with smoking cigars going, "Hey, I got an idea. Let's call this stuff a work for hire, and we'll own it forever."
Yes. Now, just a little inside secret here. Out of the three majors, the only one really making a big deal about this is the Universal Group.
They're the only ones fighting.
Correct.
It.
That's right. And
well, I mean, I would think everybody would want to fight it, because you're losing your cash. These are like these catalog albums are just a great source of cash.
Yeah. Let me give you. So I'm a lawyer, and I work full time as a lawyer. I also run a record label called Manifesto. We have the Dead Kennedys catalog. But
look at that! I told you he was cool.
But thank you. And but I've over the last year and a half, I've been doing nonstop terminations. This is the list of people I've helped get their terminations served on record companies, publishing companies. I've done it for Modern English, Buzzcocks, Stiff Little Fingers, Stranglers, Gary Newman, X, Suicidal Tendencies, Magazine, Nana, 99 Luftballoons.
99 Luftballoon.
3 O'Clock.
Yeah. Formerly the Salvation Army.
That's right. Lords in the New Church.
Wow.
Europe, as in the Final Countdown.
Oh, yeah. Up until then, you had my entire record collection, and then now we got to Europe, and
it's a good song.
I say, good for them.
Yeah. And then some mainstream artists, Stephen Bishop, Denise Williams. I've also done Todd Rundgren, the Blues Brothers.
The Blues Brothers.
Blues Brothers. I got the Dan Aykroyd signed the termination.
Wow.
And Nick Gilder. Those are a few of the names. That's just a partial list. But the thing is, let me give you some. Can I go over the few technical aspects?
Maybe we'll take a break, and we'll come back, and we'll get into it, and we'll regroup. Okay. The Barely Legal Radio program. I'm talking to Evan Cohen, and Evan Cohen. Just for people right now, before we take a break, how do people get a hold of you if they were going to talk about, like, how you might know somebody in a band that this would apply to? How do they get a hold of you?
That's right. If you know anyone in a band, or you were in a band, or you have a recording from, let's say, 1979 through 1985. Send me an email at esc@manifesto.com.
esc@manifesto.com. All right, we're gonna come back, and we'll get in a little more detail about it. This is Joe Escalante with the Barely Legal Radio program. We'll check the traffic, and we'll be back right after that.
I just wanna love her like any other. What do I get? I only want a friend who stay to the end. What do I get? What do I get? Oh, what do I get? What do I get? Oh, what do I get?
It's the Barely Legal Radio program. We're talking to Evan Cohen tonight, special guest, and he's been talking about this law that's been on the books, which even your host was, just forgets about or doesn't pay attention to because it's too hard for me. But there's a termination for people who have record deals that are, even though they're perpetual deals, and someone gave them maybe a lot of money and said, I'm paying for these recordings and I'm going to own them forever. Read the contract. You have your lawyer. Everybody's negotiating supposedly at arm's length. But 35 years later, you get it back because of this termination that's been on the books. I was shocked that was already on the books. Everybody knew, but we didn't know it would apply to sound recordings. A long time ago, they thought it would only apply to movies and things like that, right?
Well,
or just a general art, like if you hired an artist and paid him a full-time salary and a wage and insurance and all that. That's what the work for hire doctrine is supposed to be
right.
for.
I think, first of all, let me just get into some little technical aspects of the little things. This only applies to the U.S. copyright. In other words, most record contracts are worldwide.
Yeah.
The record company has worldwide rights forever. On the other hand, the U.S. portion of those rights would get terminated.
Okay, so a band could get, and you mentioned, can I mention any of these other bands?
Sure.
One of them is like the Suicidal Tendencies.
Yes.
Is that one okay to?
Yeah.
Okay, so that one's just a classic record.
Yes.
So the record company that signed that in 1981, 83 is going to keep it in the rest of the world, but the U.S. rights would revert back to the band, and they could they could sign to someone else or put it out themselves.
They can sell it. They can put it on iTunes themselves. They can put it on Spotify themselves. They can make their own copies as long as it's in the United States. There's a long tradition in U.S. copyright law of terminations. This isn't the first law that has allowed artists and other creative people to terminate copyright rights. Mm-hmm. It's been going on for 150 years. This is just the latest incarnation. So Congress in 1976 felt that 35 years was a good amount of time.
For a work for hire.
Yeah, no, for not a work for hire. If it's work for hire, the law doesn't apply to it.
If the work for hire does, yeah. Okay, so they said, then what would it apply to? Give us an example of what it would apply to, what it generally mostly applies to outside the music business, this termination.
Let's say you...
what was the copyright authors thinking at that time? What were they trying to protect?
Well, I think that these sorts of termination laws specifically dealt with the music business. That was where the fight was.
Okay.
That was where
35 years ago.
Yeah, 1976, 40 years ago.
40 years ago, okay.
All these termination fights usually involve the record business and the music publishing business.
Okay.
So there's a clear shot for songwriters to terminate publishing deals that they want to get out of. Mm-hmm. And there's I believe, a clear shot for bands and musicians to terminate record contracts with regard to the United States.
Okay.
So 35 years is the number you have to keep in mind.
Okay.
So there's a 5-year window after 35 years.
And when's that 35 years, just to help my math? 35 years ago from now is what? It's like 1982?
Well, it's 1982. That's right.
Okay.
So let's say you have a record that comes out that came out in 1983.
Okay. I had one.
Yes. 1983.
Mm-hmm.
Let's talk about the Suicidal Tendencies record.
Yeah.
So Frontier...
I bought that in 1983.
Yeah. Huge record.
Mm-hmm.
Probably sold 500,000 units.
Mm-hmm. Yeah. I'd say even more.
And so 1983 plus 35 is 2018.
It's coming up.
Right. And another aspect of this law is you have to give 2 years notice.
Oh,
yes, you must give 2 years notice. And the interesting part of the 2 years notice is during that 2-year period, the record company has the exclusive right to try to make a new deal with the artist. It's like a right of first refusal.
Okay. So you either have to keep it or you either keep it yourself,
yes,
or if you get another offer, say someone says, I'll give you $50,000 advance and these royalty terms to put it out, you have to go back and offer that to the...
No, well, not exactly.
Okay.
During that 2-year period, the only...
Oh, you can only talk to these guys.
You can only talk to the original grantee.
Okay.
And the original record company.
Mm-hmm.
And any deal that you sign with another record company during that 2-year period is invalid.
Wow.
It's totally invalid. So second of all, this is a matter of public record.
So this is why you need a lawyer, because you can't just do this on your own. There's intricacies.
You could do it, but I think to do it correctly and to make sure all the deadlines are covered.
Yeah.
There's a two-step process.
I've never met a musician that could do this. So
Well,
you must have a lawyer.
It's both complicated and easy at the same time. It's a two-step process. The first step is sending what's called a notice of termination, which is basically a 2 or 3 page form that you send to the record company that owns it currently. So in the instance like Stiff Little Fingers, for instance, signed to Chrysalis Records. Chrysalis became Capitol. Capitol became Universal. And then Universal had to divest, and they give it to Warner Brothers.
Wow.
So we sent the notice to Warner Brothers.
Okay.
But a record like Suicidal Tendencies has always been with Frontier Records.
Yeah, that's a
requirement number
consistent.
2 is a majority of the members of the band need to sign. Not everyone, just a majority.
But a band like Suicidal Tendencies, all these different members, can
Nope.
they even come together, or is it just did one guy sign the contract?
It's first of all, they all 4 signed a contract, and all 4 of them played on that famous record. It's only the people that played on that particular record that you're terminating that counts for the majority. It doesn't matter who's in the band later.
So a majority of those guys.
Correct. So
Yeah.
we got 3 out of 4
Okay.
to sign a notice of termination. We sent it to Frontier Records, and they will lose the record in 2 years unless they make a deal with the band in which they get to keep it.
Okay.
They meaning the record company.
Right. So there is a shot. There.
There's a shot,
There's
but-
like, hey, everybody can re-examine it and say, well, how 35 years later, how great of an arrangement is this for both sides? And if there's,
Yes.
you can reevaluate it.
What's interesting is that I think all the major artists, the Bruce Springsteens of the world, have sent notice to Sony saying, I'm terminating the contract. And quietly, Sony would renegotiate a big deal like that and say, whatever you want, we got to keep those records.
Yeah.
Whatever you want.
Right. So it opens up another conversation.
That's right.
And the deep pockets are on the record label's side.
That's right.
And so they can come. But a label like Frontier, I feel sorry for, because that's not a label where they got very much money. So they're just kind of like, oh, we're going to lose
look
it.
on the bright side. They got 35 years. They're going to keep foreign.
Right.
They only lose the United States. They still get, sync license income if that comes in for the foreign.
Yeah. Okay.
So it's not so bad, really.
Well, that's an interesting question. Let's say they I got like 30 seconds, and I'm going to keep you on one more segment if you can.
Sure.
Can you stick around one more segment? We're out. Okay, we're gonna come back, and I'm gonna ask you a question about that, because if you sign a movie, if you license a song to a movie, and then the movie's distributed internationally, who's going to collect the money off of that? It's a little inside baseball, but we'll talk about that and other things when we come back. We're talking to Evan Cohen about record company termination and the copyright law. 877-520-1150 is a number. Barely Legal Radio.
Told him you were living downtown.
All right, it's the Barely Legal Radio program. Joe Escalante here with super attorney Evan Cohen. Evan Cohen, and if you want to reach Evan Cohen, usually I got nothing to offer anybody on this show. Today I got something good. We got Evan Cohen. He's going to tell you how to get out of your record contract. You record a record between 79 and 80.
Well, really, anytime after 79 at this point.
Oh, anytime.
And I would say that up until about 1990 is when you can send notices.
Okay.
Because you can send notices, which is you can send notices with as much as 10 years notice.
Mm-hmm.
So we can send a notice, if you do the math, 1990 is in play right now.
And then then 1991 becomes in play, and it just never goes on forever.
It keeps.
So
going.
you're in the termination business
forever.
Wow.
Apparently.
Hey, maybe I can get out of my 1996 Nitro Records deal.
That's right, and you can send the notice in just a few years. But
I'm starting to like this.
One more technical aspect. I said earlier that the first step is sending the notice of termination, which has to be signed by the right people and sent to the right people.
Yes.
After you've done that, you need to take a copy of the notice and send it to Washington, D.C., to the Copyright Office, and they will record it in the Copyright Office so it becomes a matter of public record so everyone can see it. It's just a matter of the way we deal with copyrights in this country.
Yeah, they're public because it's a public protection, so it's available to the public.
It's public knowledge, and anyone can look it up at copyright.gov. If you're interested in this topic, of course, please go to copyright.gov and take a look at some materials there. But you can look up any copyright there. It's very easy. So this is let me just say, because we're in the last segment here, this is the law that the record companies and the music publishing companies don't want you to know about.
But they did negotiate it knowing full well that it was coming.
Of course they did. And they knew it, but it was so far in the future that no one really gave it much thought. Everyone thought, I'll be retired by then, or,
someone else's problem. Kick the can.
That's right. We'll just roll the dice, and because Congress was going to do it anyway. There wasn't much they could do about it. And also, there's nothing they could do about it contractually. The law says that you get these rights whether or not you've made an agreement that says you're not going to. In other words, if it said in your original record contract, I'm not going to exercise my rights under Section 203, that would be invalid.
And because I see some in the record contracts where they will say, like, if work for hire is deemed to be invalid, you hereby assign these. So they've kind of thought of everything, but you're saying even though that language is in there that says even if this happens, you hereby assign the rights to these recordings that to us in perpetuity. But you're saying that language isn't necessarily valid either.
It's not valid at all. I mean,
not at all.
Not at all. Not even the least. It's even less valid than saying it's a work for hire, because what you're doing is, again, you're not.
It might scare some people from getting litigious because they read it and say, "Hey, didn't you read that? You're in a lot of trouble if you go after me because you signed that."
Well, that's what
people get scared, right?
That's what Universal is trying to do. They're trying to scare people. They're trying to scare you out of exerting your rights. But
because you might get in a protracted legal battle, is that what they're trying to scare the artists on? Like, hey, this could cost you more than you're ever going to achieve by doing this.
Well, there's an attorney's fee clause. So loser pays under the Copyright Act under declaratory relief action. So it's pretty messy, but the law says that you have these rights, and there's nothing in a contract that can be written that can avoid that. There's only one thing they can do, and that's after they get the notice of termination, they can make a deal with you for the rest of the copyright.
Oh, for the rest of the copyright.
That's right. Now, if they want to do that, they can do that. If they don't want to, they don't have to. Or if they make you an offer, you don't have to take it. You can say, well, no, I got another company that wants to do it, or I want to own it myself, or I want to make records and sell them at the shows, or whatever it is.
Right. Yeah.
So
or I want to give it to my kid. He wants to start a record label.
One more point that's very important. It doesn't matter what nationality you are. It doesn't matter whether you're British or German or Japanese or Australian. This law applies to the U.S. copyright of any song in the world. Remember, copyrights are divisible by country. Every song has a U.S. copyright, just like it has a UK copyright and a German copyright. It doesn't matter that the song came out in Germany. There's still a U.S. copyright for it.
Does it matter if it was a registered copyright?
It does not matter that it's registered. In other words, that's another good thing. These copyrights that you're dealing with, they don't have to be registered.
And you as the artist wouldn't register them anyway. The record label would register the masters. You would only register the publishing.
That's right. Traditionally, the record company files the SR copyright form, standing for sound recording. The music publisher would file the PA form. And usually the songwriter and the recording artist don't get involved in that.
Yeah.
On the other hand, sometimes it happens.
Yeah, people just register. No, I'm going to register this. And
that's right. Or you register it as a demo tape or as a collection of songs is an effective way to do it. But so it's really a very useful law. And so if I've been helping people in Germany and the UK. I've said to them, look, you may not get the copyright back for the UK, but you're going to get the copyright back for the US.
Right. Wow.
And you can, if you can start a label
right,
in the US.
Right. And if you have, let's say you're a French band, like or that band that does that French punk hit that everybody likes,
Samplon pour moi.
Yeah.
That's Belgian, actually.
Oh, it's Belgium? Okay.
Yes.
So you're this Belgian guy, and it was released by a record label in Belgium, let's say, and you never been to the United States, and But there is a copyright because they were, it was getting distributed over here. So there is an inherent copyright in the United States, you're saying,
Yes.
and you could get that back.
You can get that back.
And you could prevent them from distributing, because you could have, even though you've never been in the United States, you could have the exclusive territory to distribute that.
That's right. And that song particularly doesn't apply because that's prior to January 1st, 1978. I believe that's a 77.
Super old school.
Yes. But as far as like most punk rock records,
The Damned.
The Damned is a good example. Not the Sex Pistols, because that's 77. But just like we're talking about Buzzcocks. Buzzcocks, perfect example.
Toy Dolls.
Buzzcocks are going to own those recordings. Stiff Little Fingers are going to own those recordings, and they can do what they want with them. In the United States, they can't do what they want in the UK, but they can certainly, when they come here and tour, they can make their own records, put them on the merch table.
Yeah. I got a good idea what to do with them. Put them out on Manifesto Records.
Yeah. Oh, by the way, the Dead Kennedys got back the U.S. rights to fresh fruit for rotting vegetables from Cherry Red, based on this termination
now,
law.
Cherry Red was that an English label?
Yes, it is.
Okay, so they now have the U.S.
No. Cherry Red paid for that record in 1980.
Okay.
So for 35 years, Cherry Red, a British label, owned the most important punk rock record ever released by an independent band, which is Fresh Fruit, right?
Yeah, arguably, yeah.
So Dead Kennedys sent a termination in 2013 and said, we are terminating this effective 2015 because that's 35 years after 1980. And they got it back. Cherry Red gave it up. And now that record is on Manifesto for domestic.
Wow. Yeah. So it seems like at the time, it seems like it's all working exactly the way it was supposed to work at the time this was arranged between the labels and the who do they deal with, like congressmen and stuff like that, to get it written into the agreements?
Yes. Well, there was a lot of negotiation leading up to the 76 Act. It took years and years and years to negotiate that. It was a back and forth struggle between music publishers, book publishers, the ASCAP,
players.
BMI. Yeah. And by the way, speaking of people who I don't know why, but ASCAP and BMI have been very lax on informing songwriters about this law.
That I think you're right about that, because songwriters don't know about this, and they should get more involved in that.
They should get notices in the mail from ASCAP and BMI. You know why?
Yeah.
Well, I suspect because ASCAP and BMI don't want to piss off their major publisher clients.
The ones who make the decisions on which performance rights society their clients will affiliate with.
Right, and also they're large, and they're on the boards of all these organizations. And it's like, does the RIAA want musicians to know about this? Of course they don't.
Right. Oh yeah, the RIAA, they're the record labels. Yes. They don't want anyone to know about.
They don't.
Well, my brother-in-law Evan Cohen is the president of ASCAP, so I'm going to give him an earful at the next family gathering. All right.
Oh.
Mr. Paul Williams.
Oh.
So it's the kind of things that we talk about, and I like to poke him about a few things. So I'm gonna ask him about this. You can tell he doesn't want me to come to Thanksgiving.
Maybe he hasn't heard of it.
I'm gonna talk to him about it. See what he says.
Yeah.
We'll get his he's a nice guy. If there's a way to benefit artists, he's gonna do it. That's how this guy. That's why he's a great president. But obviously he's we got to get something going with this, because I agree with you. I'm a member of CSAC. I've never heard of this.
Right.
I mean, I heard of it other than I see it in little cases you're involved with. I read about it, and then I don't think it applies to me. And here you came here, and it's like, wow, this really applies to me in a certain way, and so many more people than I thought it applied to it. It's a little larger in scope, and you really enlightened us on this, and I'm happy that you came in.
Well, thank you. Again, please contact me at esc@manifesto.com. I love to talk about copyrights. I'm not charging anyone to have discussions about these things. I like to hear what the situations are, and if there's something I can do to help.
Right, just pick. They can pick your brain on what might work for them.
That's right, because
that's valuable.
Sometimes these get very technical, like, what if people are dead? What if band members have passed away?
Yeah,
What if What
Yeah,
if-
do you have to go to the air? Like,
yes, you do. You have to go to the
you
either
get the grandmas kind
no,
of come out and
the
sign
first,
something?
It's either widow, children. Those are the first people.
Yeah,
And if they don't have that,
parents.
executors. And if you don't have that, it's a free for all.
If there's no parents, like
Parents could be.
yeah. I mean, I pay a lot of royalties on my label to parents of dead
Oh.
musicians, and we just pay them. It's not a lot of money, and we just keep paying them, and
Right.
we just do it as we don't try to figure out who's what. We just
But a
we
lot
don't
of little
wanna send
issues
them.
come up with that. Like, well, one guy doesn't want to sign it, but we
Yeah.
have.
Oh, well, it opens up a can of worms. It's like
Yeah.
all of a sudden one of the musicians, it's my time to, I've been waiting for this opportunity to stick it to everybody else in this band that I don't like anymore. And I'm sure you've had your share of that.
Right. But remember, you need a majority.
You need a majority. All right.
That's right.
All right, Evan Cohen, we're going to follow up with you on this, and I'd love to have you again for all kinds of stuff because you're smarter than me.
Oh, thank you. Thank you.
And that helps a lot. All right, the number to call the show, 877-520-1150, 877-520-1150. And remember, we are brought to you by LegalZoom. You type in vandals at LegalZoom. You save money on copyrights, trademarks, LLCs, and corporations. The estate planning bundle, that's what everybody likes over there now. The estate planning bundle. For one price, you get either a trust or a will. You can figure out maybe you need both. And you have enough help from an attorney just to get you through that thing. And then you're done. People like that. They tell me that's they're going like hotcakes. All right, Barely Legal Radio.